Finally, we deal with remedies and real property. Real property is a complicated, difficult subject. And one of the reasons why that's true is because remedies issues come up in real property in a much broader context than they do in any of the other subjects. All of the law of remedies from torts can come up here in real property. All of the remedies from contracts can come back up here in real property. I have said from the very beginning, remedies is the most important topic on any bar exam in this country. And the reason remedies is so important is because it allows us to answer the questions. Anytime we are dealing with civil litigation, we know that a plaintiff is going to have a theory of liability and a prayer for relief. In real property law, we see more often than anywhere else plaintiffs who are seeking equitable relief, because both in the law of torts and in the law of contracts, equitable relief is more readily available when the dispute involves land. All real property parcels are unique, and as a result, litigation dealing with land tilts towards equitable remedies because money's not good enough. What the parties really want is interests in land to be respected and enforced by the courts. So, here in the law of real property, the basic structure of our concerns about remedies remains the same. The basic approach to remedies, regardless of the subject at issue, is damages, restitution, and equitable relief. Here in the law of real property, damages issues can come up really at just about any point of the outline. Anytime we've got a party litigating the value of an interest in land, there's the possibility for damages. If we're dealing with a land sales contract, obviously the preferred remedy is specific performance, but where a specific performance order isn't feasible or for some other reason isn't available, a successful plaintiff will have to be content with damages. We've also seen in a number of places where a party seeking damages based on a real property theory of liability may have a couple of different ways to calculate those damages. Where real property has been damaged, physically damaged, the possible ways to calculate those damages are either the cost to repair, to put the land in the same position it would have been before the injury, or the diminution in value. Essentially here, we're saying the property can't be repaired. All we can do is make the plaintiff whole, to the extent that's possible, by paying damages. So we see here in real property that the big difference between damages and restitution is where we are focusing our attention. When we're concerned about damages, we are concerned about the plaintiff. We look at the plaintiff, we assess his or her injuries, and we try to put a dollar value on those injuries to make the plaintiff whole, to put the plaintiff in the same position he or she would have been in had the defendant behaved. Now, compare that with restitution. Once again, restitution focuses our attention on the defendant, not the plaintiff. With regard to restitution, our concern is preventing unjust enrichment. So, in damages, we try to make the plaintiff whole. In restitution, we focus on the defendant, and we try to prevent that defendant from becoming unfairly richer than that party would have been otherwise. That's the difference between damages and restitution. But notice, here in the law of real property, we can have the special remedies that are associated with contracts. Here, reformation and rescission. Reformation is commonly available in land sales contracts where the land isn't properly defined or where it is described incorrectly. A court will use equitable powers to fix the contract so that the true intent of the parties is reflected in the document. And typically, parole evidence is admissible for that goal, to resolve the ambiguities with regard to descriptions of land or other statements in a land sales contract or a contract for some other lesser interest in land. Also, rescission is available to land sale contracts, just as it is in all other types of contracts. If there has been a mutual mistake that is so serious that it goes to the essence of the contract, a court could very well just tear up the document and say to the parties, you folks never did have a contract, and to the extent one of you thinks they did, we're just rescinding it. You guys can go start over. So we see that damages in the law of real property are as elaborate as they can be anywhere else in the law. Restitution, fairly straightforward. Rescission and reformation, available in a real estate contractual context, but here we're really dealing with the law of contracts, not the law of real property. And then we finally turn to equitable relief. And we'll see that both of the big types of equitable relief come up regularly in the law of real property. Specific performance of contracts and injunctive relief to enjoin tortious conduct. And here, analytically, the structure that we bring to the analysis is identical to the structure that we use in either contracts or torts. So, as we consider specific performance, we've got first to establish that the plaintiff can't be adequately remedied at law. And here, that's fairly simple, because real property is unique. Thus, damages are not the preferred remedy. Damages are inadequate per se when we're dealing with interests in land. Is there a definite and certain contract? Well, in order to establish this element, we've actually got to examine the agreement and see if it's specific enough. This is not fairly difficult, but we do have to consider the facts presented. Is it feasible for the court to enforce the agreement? Here, the issues are no more complicated than they are in contracts, often less so, because where a court has got in personam jurisdiction over the parties and in rem jurisdiction over the subject matter of the contract, the parcel of land, specific performance is feasible. Mutuality is almost a dead letter with regard to specific performance. Still, mutuality typically is present with regard to land sales contracts. The court could easily order either party to perform specifically. Defenses to specific performance here are identical to all of our other defenses in equity: latches, unclean hands, etc. These are available. Whether or not they will prevail depends on how you choose to analyze the facts presented. Next, we consider temporary and permanent injunctions. This is identical to the law of torts because that's where it comes from. So, in the law of torts, we've already studied enjoining nuisances, and that's exactly the sort of thing that goes on here. Once again, a plaintiff seeking an injunction based on an underlying property that deals with real estate, that plaintiff has to show that damages are inadequate. Once again, the legal remedies are preferred, although they aren't preferred by plaintiffs dealing with interests in land. And ultimately, a court will defer to that preference of the plaintiff here. So first, the legal remedies have to be inadequate. There's got to be a property interest at stake. And here, there's always going to be a property interest at stake because we're dealing with the law of real estate. So, although modernly the courts have defined property interests very broadly for purposes of torts law, a question that arises out of real estate is about as straightforward and easy as they come with regard to establishing the property interest. Again, feasibility comes into play, but here again, feasibility is typically not an issue. The court will typically have in personam jurisdiction over the parties. Often the court will have in rem jurisdiction over the real estate at issue, and so it is very feasible for the court to order performance. But consider it a little differently. Suppose the court has got in personam jurisdiction over the parties, but the parcel of land is somewhere else. Does that in and of itself make it impossible for the court, or not feasible for the court, to order an equitable remedy? Answer: probably not. It will complicate matters a little bit, and it's something that you should consider in your analysis. But where the court has got proper personal jurisdiction over the parties, the contempt power that the court has typically is enough to establish feasibility, even where the parcel of land at issue is not in the jurisdiction that the court is sitting in. Next, when a court is trying to issue an injunctive order, that court will balance the hardships between the parties. And where the hardship to the defendant becomes too great, that will make it unfair. and thus a court will not impose an equitable order. And even where the court does balance the hardships and finds that the hardships balance out in favor of equity, the defendant has still got possible defenses to equity. And if any of those defenses are persuasive, even though everything else stacks up in the favor of the plaintiff may ultimately have to rely on legal remedies, which typically are damages. Remember, with regard to specific performance and injunctive relief, the court is sitting in equity, and if the court judges it to be, on balance, unfair, the court will limit the plaintiff to damages and will not issue an equitable order. So, that wraps up a consideration of remedies as it relates to real property. You'll see it's strikingly similar to our consideration of remedies both in torts and in contracts. What makes this more interesting and a little bit more difficult sometimes is all of this remedies outline can be at issue here in the law of real property, whereas only a subset of it is available when we consider torts and contracts.